Hi, good evening. This is a Bombay High Court judgment, interesting judgment. Citation is Smruti Vagdare versus Joint Director, Directorate General of GST Intelligence and others. So I may not have spelled the pronounced the petitioner name correctly. Smruti Vagdare. It's okay. So pardon me for that. Issue is, can department seize the cash found at the premises of a person carrying on business? That is the issue. The facts of the case, very, very simple facts. X is a proprietor of a firm which was in the business of metals and scrap. Searches were conducted on the basis of an authorization naturally issued by the joint commissioner at the office premises owned by X, residence of X, and residence of his parents. So, four places the searches were conducted. There was some search conducted at the premises of his friend also. Department seized cash of rupees 1 crore from the premises belonging to X. So they found some cash lying, more 1 crore it was there. They have taken the cash, seized the cash. This was challenged by way of a writ petition before Bombay High Court. So the contention was under section 67(2), you cannot seize the cash. You can seize any other thing, document, things, laptop, anything you can seize, but not the cash. That was the contention. Bombay High Court looked into section 67(2). Bombay High Court said the condition precedent for seizure under section 67(2) of CGST Act is that the goods, documents, books, or things are liable for confiscation. One. Two. The proper officer, not below the rank of joint commissioner, he must have a reason to believe that the same are useful or relevant to any proceedings under the CGST Act. Under the GST Act. So, condition precedent is you must have a reason to believe that the goods or things or documents seized are useful for any proceeding. Department has completely given a go by to the expression reason to believe, which is the bedrock of initiation of proceedings under section 67(2). That is the opinion of Bombay High Court. Why? Because no reason whatsoever was recorded that the cash found at the premises was liable to confiscation. There was absolutely no reason recorded why that cash was seized and how it is useful for conducting any proceeding. Second is, the Bombay High Court said there is no power under section 67(2) to seize any cash. That is also one of the reasons given by Bombay High Court, because if you read section 67(2), it gives power to seize any goods, documents, books, or things that are liable for confiscation. So whether uh, money can be seized, that is the thing. Court says no power under section 67(2) to seize cash. Then third, the department failed to follow section 67(7) in the opinion of the court, because according to that section, notice has to be given within a period of 6 months of seizure. So whatever you seize, within 6 months you have to issue a notice from whom the goods are seized or the documents are seized and ask for explanation. No notice was given or issued within the 6 months. Then there is one more interesting thing which happened. Court asked the department, okay, you seized 1 crore cash. Where is that cash now? The court asked. The department said that 1 crore cash we have handed over to income tax department for initiation of proceedings under income tax act. That is the submission made by the department. Bombay High Court was surprised and dismayed at the attitude of the CGST authorities because there was no provision under the CGST Act which provides for such a transfer. You cannot act at your. They did not know. Actually, the authorities were not knowing what to do with the cash seized. So what they did was, we will give the cash to the income tax department. They have decided and they have given it to the income tax department. So, but under which provision you transferred, the department was unable to answer that question because there was no power to transfer the cash from one department to another department of the central government. So, Bombay High Court quashed the seizure order and directed the department to return the cash to the petitioner, that is X, by deposit in his bank account along with interest. Uh, Not much of a comment, but I am surprised at the way the higher officers in the CGST department are taking decisions. How did they take the decision to hand over the cash to IT department? On what basis? Uh, did they take a opinion from the central government standing council or the senior councils before transferring it, or did they do it on their own? Because law executing officers have to be more thorough with the law than the, because ignorance of law when it comes to the business people, it is not an excuse, but when it comes to the department, whether it can be excused, that I am not sure. uh, Secondly, the department thankfully did not say, sorry, there, this amount has been lost. Many times they say it is lost or it is spent for some other purpose. They did not say that. Thankfully, it was given to the income tax department. Uh, but how, whether the department will get it back from the income tax department and then transfer it to the petitioner, or they will pay on its own. That also, there seems to be some trouble for the for getting the money for the petitioner. Anyway, court has directed. The hope the petitioner gets the money at the earliest. Thank you very much. Have a great evening. Bye.